Hi, everyone, and thanks very much, Owen. I'm going to talk about an aspect of the Meta Platforms judgment, which has been given some attention, but I don't think is really being given enough attention, and that's its procedural implications for data protection authorities and for other national regulatory bodies and other national authorities. So, as Owen mentioned, the origin of these proceedings was an investigation brought by the German Federal Cartel Office against Meta, which found that the way that Meta processed users' personal data in accordance with its general terms amounted to an abuse of dominance on the online social network market. And the basis of that finding was essentially that the processing of data relating to off-Facebook activities of users in accordance with Meta's general terms was incompatible with the GDPR. And that decision by the Federal Cartel Office was appealed to the German courts, which then made a preliminary reference to the CJEU. And amongst the questions that were referred to the CJEU were the two that are on the screen there in summary form. So first, whether the competition authorities of a member state can find, in the context of their examination of a possible abuse of a dominant position, that an undertaking's general terms of use relating to the processing of personal data and the implementation of those terms of use are consistent with the GDPR. And second, if so, whether it's possible for a competition authority to make such a finding where those general terms are being investigated simultaneously by a competent supervisory authority under the GDPR. So, what was the CJEU's response to those questions? And the answer to the first part of the question was really a relatively straightforward yes. And the court got to that yes in essentially 3 steps. So first, it looked at the role of data protection authorities under the GDPR and the one-stop shop mechanism, or the cooperation and consistency mechanism under the GDPR. And the court correctly noted that that one-stop shop governs cooperation between data protection authorities and between data protection authorities and the EDPB. But neither the GDPR nor any other instrument set down any specific rules on cooperation between data protection authorities and national competition authorities. Then, second, the court said that nothing in the GDPR explicitly prevents national competition authorities from finding that data processing operations don't comply with the GDPR, and the GDPR is completely silent on that point. And third, the court observed that data protection authorities and competition authorities carry out different tasks for different purposes. So the tasks of a data protection authority are to monitor and enforce the application of the GDPR for the purpose of the protection of individuals' fundamental rights to data protection and to facilitate the free flow of data. And on the other hand, competition authorities operate within a different legal framework with a different objective of ensuring that competition in the EU internal market is not distorted. So it said that while compliance with the GDPR might be a relevant circumstance in determining whether an undertaking's conduct complies with competition law, national competition authorities aren't involved in monitoring or enforcing the application of the GDPR for those purposes of protecting fundamental rights and the free flow of data. And similarly, competition authorities aren't involved in exercising the powers that are available to data protection authorities under the GDPR. And it said that the sole reason why a competition authority might be making a finding of non-compliance with the GDPR is for the purpose of establishing an abuse of dominance. So, arriving at that conclusion, the court essentially rejected the idea that the GDPR and that sort of bifurcated public-private enforcement regime that it foresees is a self-contained regulatory code. Rather, what the GDPR does is create general obligations which are applicable to all actors in all situations falling within its scope. And so consideration of an undertaking's compliance with the GDPR doesn't fall within the exclusive remit of data protection authorities or the courts under the GDPR. And national competition authorities are entitled to make incidental findings of non-compliance with the GDPR within the context of their own legal regime and for their own purposes. And that's quite a realistic conclusion. I think it reflects the general nature of the obligations under the GDPR. So if you take, for example, imagine a body exercising powers of inquiry. It must surely be able to make incidental findings that data was obtained unlawfully and not in compliance with the GDPR for the purpose, for example, of determining whether that evidence is admissible in investigatory proceedings. Similarly, requirements to comply with data protection law often form part of professional regulatory codes of conduct, which might be the subject of proceedings before disciplinary tribunals. And I would say that disciplinary tribunals must surely be able to make incidental findings that the GDPR has been contravened by a regulated person when determining disciplinary proceedings. And similarly, regulated entities might, under their own regulatory regimes, also be subject to GDPR obligations. So, for instance, under the Central Bank Acts, where a credit servicer fails to comply with a borrower's data protection obligations, that can constitute a prescribed contravention, which can be investigated by the central bank under the Central Bank Acts. And so none of this would be possible if enforcement of the GDPR was something that was within the exclusive regulatory remit of the data protection authorities. So to this extent, I think the Meta Platform's judgment, insofar as it concerns enforcement, really makes sense. So far, so good. But it's at this point that I think the ECJ arguably took a wrong turn. And the issue that arose at this point was that if national regulatory authorities can, within their own remits, make findings of non-compliance with the GDPR, how do we mitigate the risk of inconsistent application of that regulation by different administrative and regulatory bodies? And the GDPR regulates cooperation between different data protection authorities, but it doesn't say a word about cooperation between data protection authorities and other regulatory authorities. So there is a risk there that the different regulatory bodies, without the benefit of the cooperation and consistency mechanism under the GDPR, might arrive at different conclusions regarding how the GDPR works or applies in practice. Now, one might have thought that there was a relatively simple solution to that, namely that the decisions of data protection authorities and other regulatory authorities are subject to review by the courts, and the consistency of the application of EU law is essentially controlled by way of Article 267 TFEU and the preliminary reference procedure. But the approach taken by the CJEU was, I think, quite a bit more complicated than that. So the CJEU said that while there are no specific rules governing cooperation between data protection authorities and competition authorities, the national authorities are nevertheless bound by the duty of sincere cooperation under Article 4.3 of the TEU. And so, because of this duty of sincere cooperation, when national competition authorities are examining whether an undertaking has complied with the GDPR, they're required to consult and cooperate sincerely with competent data protection authorities. Now, what does this duty of cooperation mean in practice? And this is where I think things get a bit tricky, because the court didn't really engage with any authority at all on this point. And what it did was it instrumentalized the duty of sincere cooperation into a relatively detailed and concrete cooperation procedure, which I think it sort of conjured out of nowhere, which data protection authorities and national competition authorities are required to follow. And so it said that first, where a national competition authority is examining whether an undertaking's conduct complies with the GDPR, it has to ascertain whether that conduct or similar conduct has already been the subject of a decision by a data protection authority. And where there is a decision of a competent data protection authority in respect of that conduct or similar conduct, then the competition authority cannot depart from that decision. The decision's binding on the competition authority. Where the competition authority has doubts regarding the scope of any assessment carried out by a data protection authority, so where there's no final decision, then it's obliged to consult and seek the data protection authority's cooperation in order to dispel this doubt. And it has to seek this cooperation of the data protection authority where the conduct is under investigation by the data protection authority. And where the data protection authority isn't investigating the matter at all, the competition authority still has to seek its cooperation, where it takes the view that the conduct isn't consistent with the GDPR. And if the competition authority does seek the cooperation of a data protection authority, the data protection authority has to respond to the request for information or cooperation within a reasonable period of time. And the data protection authority is obliged to provide information capable of dispelling the competition authority's doubt as to the scope of the data protection authority's assessment, or inform it if it intends to initiate the Article 60 cooperation procedure. Now, I think that reasoning is difficult, essentially in that it elevates the binding nature of a data protection authority's decision beyond what's foreseen by the GDPR. So it applies quite an expansive vision of the duty of sincere cooperation, which in effect accords data protection authorities' decisions a precedential value that they don't have under the GDPR. And so competition authorities are bound to follow data protection authorities' decisions, not just where those decisions address the same data processing activities that are under investigation by both bodies, but also where the data protection authority's decision relates to analogous situations involving similar types of processing or similar general data protection terms and conditions, potentially involving different undertakings and not the same data controller. But we are where we are. That's what the CJEU has decided. And so I just want to look at some potentially difficult practical implications of the cooperation procedure, which has been conjured up by the ECJ. And there are a number of practical implications, I think, for both data protection authorities and for other administrative authorities and regulated entities. So the first issue, I think, is that this judgment relates to cooperation between national competition authorities and data protection authorities. But I don't think there's any reason in principle why the judgment doesn't also apply to cooperation between data protection authorities and any other national authority, which might be required within the scope of its own remit to make incidental findings of non-compliance with the GDPR. I mentioned in the beginning that it's not difficult to envisage various types of national authorities that might be called upon to make incidental findings that certain processing activities don't comply with the GDPR, such as professional disciplinary tribunals. And I mentioned specifically the powers of the central bank. So it's possible that these entities, as well as national competition authorities, might also be under this duty of cooperation with data protection authorities and to seek information and cooperation of the data protection authorities before making any incidental findings of non-compliance with the GDPR. And it also seems to be the case that the duty of cooperation doesn't just apply in cross-border situations, which were at issue in the Meta Platforms judgment. I think the judgment seems to indicate that the duty of cooperation might apply even between a national competition or other regulatory or administrative authority and the data protection authority within the same state. And that's because the overriding concern was to ensure the consistency of application of the GDPR. And indeed, in this case, the court noted that the German Federal Cartel Office had cooperated with the German data protection authorities, and that to an extent satisfied its duties of sincere cooperation. So I think the judgment seems to envisage, although it's maybe open to question, that the consultation obligation applies in situations which are confined within a single member state. So it's got pretty broad consequences there for regulators and other national administrative and regulatory authorities. And I think in practice, they'll all need to work out really the extent to which this quite vague judgment might affect them. The second difficulty, I think, in practical terms with the judgment is that it potentially creates risks for data protection authorities which are engaged in the new cooperation procedure. So, as I mentioned, the judgment imposes obligations on competent data protection authorities when they're called upon to cooperate with another national authority to respond to a request for information or cooperation within a reasonable time. And in responding, the data protection authorities are obliged to provide the requesting authority with information in its possession capable of dispelling the authority's doubts as to the scope of the assessment carried out by the supervisory authority, or, where appropriate, by informing the National Competition Authority if it intends to initiate the Article 60 cooperation and consistency procedure. And this duty to provide information to another authority applies during the currency of the Data Protection Authority's investigation, so not just once it's already made a decision. And it isn't really clear from the judgment what the scope of that obligation is and what sort of information might be required to be provided by the Data Protection Authority. So, does it require the Data Protection Authority just to inform the requesting authority of whether it is or isn't investigating a particular data controller or particular incident or active processing? Does it require the Data Protection Authority to provide the requesting authority with information concerning the scope of the investigation or information obtained from the controller or a complainant? Does it require a Data Protection Authority to express a view or a preliminary view on whether the GDPR has been complied with prior to reaching a formal decision? I think on one reading of the judgment, it might require that. And how does any of this fit within a Data Protection Authority's confidentiality obligations within the context of investigations? If the Data Protection Authority is required to express a view on whether a particular set of general terms might contravene the GDPR before it arrives at a formal decision, that could engage the rights of fair procedures of the undertakings being investigated by the Data Protection Authority. And so there's a potential sense that the Data Protection Authority might need to give an undertaking a right to be heard during that procedure. The judgment is essentially silent on all of these aspects. And I think data protection authorities will really need to think quite carefully when complying with it what other rights and interests are engaged during the cooperation process and whether they're opening themselves up to any risk if they provide certain information or provide information in a certain way to other authorities. And the final difficulty, I think, with the practical issues arising out of the judgment is that it creates some risks and ambiguities for the national authorities that are required to follow the Data Protection Authority's decisions. So what does it mean for another national authority to be bound by a Data Protection Authority's decision on whether particular processing activities or general terms contravene the GDPR? In the Irish context, is a decision of the Data Protection Commission only binding on another authority where it's a decision made on foot of a formal statutory inquiry, which is a legally binding decision within the meaning of the Data Protection Act? Or does, for example, a formal outcome to a complaint under Section 1095 of the Data Protection Act, but which isn't strictly a legally binding decision under that Act, bind another authority? Now, that's something that this judgment is unclear on. And what happens where a data protection authority has arrived at a decision, but that's subject to an appeal or a potential appeal? Does that decision benefit from some sort of presumptive validity? Does it still bind another authority? Again, these are questions that are left open by the Meta Platform's judgment. And finally, does the requirement to follow and to be bound by a data protection authority's decision impact on other regulators' independence or the rights of fair procedures of bodies before those regulators? I think that's particularly relevant where the requesting authority is said to be bound by a data protection authority's decision in respect of similar conduct or general terms. So that might be a decision adopted by a data protection authority in respect of one undertaking, which a competition authority is bound to apply in respect of another undertaking. Now, to what extent does that engage the rights of fair procedures of the undertaking being investigated by the competition authority if it essentially doesn't have a possibility to make submissions on whether it has complied with data protection law? That's, again, another question to which the Meta Platform judgment doesn't really provide any answers and doesn't provide any clarity. So I think in coming up with this new cooperation mechanism, without any real basis in the text of the regulation or in the case law, the Meta Platform's judgment really raises more questions than it answers. And any regulator or national authority or data protection authority which is considering its obligations, I think really need to think quite carefully about how in practice it complies with this judgment. So that's all I want to say about that. Thanks very much.